like it or not, having courts and having judges is an important rule in democracy. And it is very important that the judiciary is always an independent body separate from the government. Otherwise, that can cause a lot of problems to democracy. It allows the government to be able to influence decisions, sack and appoint judges based on political ideologies. And as a result, you may see judges, a case, again, there are many examples throughout the world of political judges being assigned to cases, basically to get the government off. And it is important that you have judges because at the end of the day, they are the arbiters that ensure that the rules that the government passes are enforced. You may not like the fact that they're there. The Brexiteers complained for years about the quote EU courts, but at the same time, their very same arguments can be levelled at the UK courts. So you have to wonder, are the Conservatives, as we suggested in their manifesto, after the judges now? Because it was the judges and the UK courts that defeated the Conservatives many times during the past 4 years during the Brexit campaign, during the Brexit stuff, the whole pre-withdrawal agreement era, shall we say. And it is very important that we fight their getting their clutches on this. It is important that the judges remain and the courts remain an independent and separate from the government. And guess what? We told you so. Giving the Tories such a dangerous majority, they are going to try this. This comes from The Guardian. This government has plans that would destroy the protection of the law. On Sunday, the Lord Chancellor Robert Buckland said that he would attempt resist to politicise and weaken the judiciary. He said he would uphold his oath as Lord Chancellor to protect judges' independence. He's taking his own government. He's talking on his own government, and we should support him. The Tory manifesto included a pledge to restrict the court's powers to take on the government. It characterised some of the recent judicial review findings against the government as abuse. The ruling against the prolongation and the Gina Miller case are presumably what they had in mind. This government is determined to prevent the courts from being a fetter on what it wants to do. It has two muzzles in mind. First, giving politicians greater influence over the appointment of senior judges, and second, taking some of the big government decisions that affect politics out of judicial review. Number 10 briefed the night before the Queen's speech in December, either ignorantly or deceitfully, for some of the decreasing power of the Supreme Court and increasing the power of the Lord Chancellor. It claims to fear that the UK courts becoming like the US Supreme Court, which decides big political issues such as abortion and deregulation. In the US, where this written constitution which sets limits on what Congress can and can't do, the US Supreme Court determines what those limits are. The Constitution, for example, determines whether everyone has the right to choose whether or not to have an abortion. In the UK, where there is no written constitution, Parliament is sovereign. It decides whether abortion should be permitted. Once Parliament has decided an issue like that, the courts can then not interfere, and they don't. Professor Richard Elkins, the head of the Judicial Power Project at the government's favourite think tank, Policy Exchange, has suggested increasing the Lord Chancellor's power to interfere with senior judicial appointments to ensure that the judicial activists don't get appointed to senior positions. He suggested that the Lord Chancellor should more often use his existing very limited powers to reject judges proposed by the Independent Judicial Appointments Commission, and should be given a new power to choose all senior judges' appointments from a short list of 3. This is wrong-headed. More politicians are involved in judicial appointments, the more political judges will become. Not in the sense that they will start to decide issues like abortion, but that they will start to decide cases in a way that will get them promoted like by politicians. At the heart of Aiken's independence reducing idea, this is the view that some, not all judges, do not respect the supremacy of Parliament, and, for example, they construe statutes in a way that do not give effect to the intention of Parliament, or decide that judicial review cases in a way that gives that seeks to frustrate the will of Parliament, giving the politicians more say in weeding out those judges who are, quote, too activist, will, he believes, ensure a cadre of senior judges who respect the line between the courts and politics. As he must know, it will lead to judges who defer more to the executive being promoted more. The other prong to Number 10's plan to weaken the Supreme Court is to declare by statute that cases such as the prorogation one last year, which involve the exercise of the royal prerogative, are beyond the reach of the courts. They are non-justable. This would have prevented the Supreme Court finding that the prorogation of Parliament was unlawful, strengthening the role of the Lord Chancellor, a Number 10 sweetener for the reduction of power and independence of the Supreme Court. The only measure it has mentioned so far, it is specifying that the Lord Chancellor should be a lawyer. Yes, that would help to avoid the Titanic disasters such as Chris Grayling or Liz Truss. But you can always find an amiable lawyer among the casualties of Harold Macmillan's Night of the Long Knives. The cabinet reshuffle was the Lord Culmer. The Lord Chancellor, he complained he had received less notice than he would his cook. Macmillan replied that cooks were a lot harder to come by than Lord Chancellors. The purpose of judicial appointments process must above all be to ensure independence of the judges from the executive. In their promotion to the Supreme Court, it depends on if their promotion to the Supreme Court depends on pleasing the politicians, their independence is crucially compromised. The ability of the Lord Chancellor to remonstrate with the Prime Minister is no substitute for the court's fairness and prohibiting of unlawful acts and the unscrambling of their consequences. The effect of declaring by statute that something is non-justable, it is to declare that it is outside the realm of law. The courts would be powerless to prevent it because it would be for the politicians to resolve, and the Lord Chancellor. The voice of the law in Cabinet would rightly be told that since the issue is outside of the realm of law, that he or she is the last person with authority on the issue. The executive can arrest, imprison, remove children, confiscate property, remove union rights, close down Parliament indefinitely, close businesses, close publications, declare law, sell arms, break humanitarian law, and deport. It is the courts, not the Lord Chancellor, that prevent these abuses of these powers. The Lord Chancellor can protest internally within the government or even publicly, and that is some value as a restraint on the government embarking on a flagrantly unlawful conduct, for example, by deliberately breaking an Act of Parliament, such as the Benn Act. But ultimately, the courts alone can prohibit the unlawful state actions. They are proudly and defiantly independent of the government. They uphold the rights of the citizens against the executive, and to do so in cases where it upsets the government's political plans. The protection of the law will be destroyed if judicial promotion is dependent on not upsetting the government, and if courts cannot rule on cases that might embarrass the state. The Lord Chancellor needs all our support to stop this. So I ultimately urge you to write to your MP to support the Lord Chancellor, to stop him, to stop this ridiculous plan of judicial appointments. Judicial appointments should always come from an independent source. They should not be, for Parliament to decide upon, because, as they said, you will have an unintended of consequence of, politicising of judges that they will not try to upset the government in attempts to get a higher promotion and position of power. This is not what we want. Again, Brexiteers, where are you on this? You claimed you want sovereignty and, quote, British law. Here you have Parliament undermining one of our key fundamental points of democracy. So once again, Brexiteers, by not, if you don't go and support the Lord Chancellor and stop these measures from being implemented, you yourself are going against one of your key principles.